Good day to all. My topic is Concept and History of ADR in India. So let's quickly move on to the topic. I'll be first dealing about the definition of ADR. So basically ADR means alternative dispute resolution. We also say it as amicable dispute resolution. It is used as these are a system of processes or system of procedures or methods that is used alongside litigation to resolve a dispute. So basically it is a voluntary structured process. Earlier ADR used to exclude litigation, but nowadays it is done along with litigation with the leave of the court, with the permission of the court, and there are even statutes regulating arbitration in India. Earlier, any person who never wanted to go to the court because of its formal procedures, delays, expenses, etc., used to resort to the ADR mechanisms, which was not very much in vogue in India. But now, it is also coming as a trending mode of dispute resolution because of its efficacy and efficiency. And also, in ADR also there is an impartial and independent third party who will be looking into the facts and arguments of both parties, and they'll quickly, expeditiously come to a resolution or to dissolve that dispute. And finally, ADR may be binding or non-binding because there are different kinds of ADR methods like mediation, conciliation, arbitration, etc., settlement, etc. So in all these cases the procedures are different, but the major point is that it is very expeditious and time saving. So this is why we need to look into the importance of ADR in India, because mainly it prevents delay. That is the first and foremost point, prevention of delay. Next one is less formal procedure requirements. As we all know, when you go to the court, there are a lot of requirements, cumbersome procedures wherein lot of money, amount, your energy is wasted because of this so as to comply with the formal procedure requirements. And if you don't comply with the formal procedure requirements, the judgment, the decree, or anything that is coming out of the result of the proceeding might not have its value, or it becomes void or something like that. Some illegality will crept into it. So it is very important to look into the formal aspect of procedural compliance when you go to the courts, but that is not required, or its value is totally not necessary when you come to ADR mechanisms. And finally, it's very less expensive for the same reason that it is less time consuming. And it is a very swift and expeditious dispute resolving method. Basically, when such a recourse is made by the parties, there is lesser burden on courts. In India, there are a lot of cases pending in courts which needs to be resolved quickly. So in such a case, ADR mechanisms comes as a boon for courts because there is lesser burden on them. And there's a fast-track system of dispensing justice through the modes of arbitration, conciliation, mediation, adalats, negotiations, etc. Now, my topic has to generally deal with the history of ADR, how ADR as a process evolved into India, its phases of evolution. So let us look on to those aspects. So I'll be moving on to ancient India. Now, in ancient India, the major issue was there was no democracy, there was no system of government. Everywhere there existed kings, queens, monarchs, and basically empires. So in such a situation, how did they resolve the disputes that was happening among their subjects? So from various texts, scriptures, Vedas, etc., you will get to know that there existed arbitration mechanisms in one way or the other. From these texts we can infer from those texts, that is Bradharna, Nayak Upanishad, and all these they were the arbitral bodies. That Upanishad was the arbitral body that contained the requirements of conducting arbitrations, and the Pyuga, Sreni, Kula, the Panchayat. So from all these texts and historical references, we can understand that the contractual, matrimonial, or even anything of a criminal nature used to get resolved. Those disputes used to get resolved even through arbitration mechanisms. Next one is ancient Indian trade guild system. Basically, guild is a unique and multifaceted form of organization, something like a self-help group. That is, the people among themselves, they make a group out of themselves, and they bring in some kind of an organization that used to basically guild system, not talking on the background of arbitration, in every other ways, that is even in the case of trading, helping merchants, giving out loans. In all these cases, trade guild system has been very was such an iconic figure because it has helped the subjects in a lot of ways. So it had the functions of a democratic government, a trade union, a court of justice, and even a technological institution. It had multifaceted, multivariant roles and importance to play. So what they did was, they in most often situations acted like an arbitration body when disputes arose, especially between merchants and traders, because only merchants and traders used to come to ancient guild system to get some kind of help. So basically, the disputes between them used to get resolved through these bodies. It was, as I have already told, it's an informal body. It is not something done under the governance of the king or the governance of the government or anything like that. It is a voluntary group. Now, Sanskrit writers call them Shrenya, and after that, even the king would enter these guilds with judicial functions. That is, even they are given some sort of power to resolve disputes between their members, and if there is any issue, an appeal can go to the royal courts. And even the disputes between several guilds were also settled by means of arbitration. We are talking about a period where battles were in trend, but still, even if there were differences of opinion and interest among different groups of people itself, even the king was also, the higher authority was also in favor of resolving those disputes by means of arbitration. And so basically, my point is, the guilds occupied a prominent place, and they also performed a duty of a subordinate judiciary, and to some extent under the authority and control of royal courts and kings. When you look into the more versified versions of trade guild system in India. Next one is what happened during Mauryan dynasty. So king was the head of justice, as always in every kind of empire. King is the justice fountain, and but decisions also were taken by a body of arbitrators with the system of appeal to the king. And at the local level, we have trade guilds, village assemblies, and mainly the guild system were used to resolve disputes between the village people, especially in minor petty cases, not something including murder or anything of a higher order degree. That will be exclusively dealt by the court. Court means the king. But in case of petty offenses like theft, something like that, in all such cases, even these village assemblies and trade guilds used to more prominently get involved in dispute resolution. Next, during Gupta age, Gupta also was not an aristocratic king, or was not an autocratic king. He was more into some kind of democracy. He used to enforce democracy, even though it was a monarchy kind of government. And there also we had village panchayats, town councils, etc. Because the thing was, the empire is so big that it transcends continents. So in such a situation, it is not practically difficult for one person, for one king to look out of the welfare and to impart justice to all the people in his country. So in such a situation, often the king used to delegate the powers to village panchayats and town councils. So there also we had village assembly and trade guilds, and they also appointed or settled disputes that appear before them. Now, if they could not reach any amicable situation, they are resolved by the councils. Councils are coming totally under the exclusive jurisdiction of the king. So often it doesn't mean that when you go for arbitration, it doesn't mean that you have to reach to an amicable settlement. Sometimes the dispute will be so vulgar that it is beyond reaching an amicable settlement. In that cases also the king will come into play, the king will get involved and then resolve the dispute between them. During Mughal rulers, we had Hedaya become to some sort of written form of codified version of arbitration laws. So Hedaya is their book which contained provision for arbitration, and the Arabic word for arbitration was Thakim, and arbitrator is called Hakam. And he had to possess the qualities essential for a Qazi. Qazi is in par with an official judge presiding of the court of law. So similarly, all the qualification that a court of law had, even the Qazi was also supposed to have that. Doesn't mean that since you're doing arbitration you have to have a lesser place or lesser place. It doesn't have such a requirement. And even the Sharia laws looked into that. In time of Akbar, Brahmins were appointed to decide the case of Hindus, and Akbar and Jahangir allowed subjects to directly petition them. And villages resolved their case in the village courts itself. And for arbitration, there was an impartial umpire, salis, or by a resort of force. Next one is Maratha rulers. We have to specifically talk about Maratha rulers because even in their goal for arbitration was, as I've showed, they showed consideration to the defeated party to ensure good relations between the parties in the future. So beyond amicable settlement of disputes, what they wanted was they wanted to maintain they wanted to maintain a cordial good relation between the defendant and the plaintiff, between the two opposing parties, even after this dispute. So they had a long vision, and it was not a confined one. And this is an important point of Maratha rulers or Maratha ruling, which is totally different from other kind of dynasties. And every village had Partill and every town had Sheti, Mahajan, and they used to adjudicate cases of simple and minor nature. And so Panchayat had to study the case, pass its judgments without any bias. There is Mamlatdar, the higher officer in the succession of judicial administration. He should confirm the judgment. But in case similarly, if these people did not reach an amicable situation, they are very much okay to move to the arbitrator and get satisfactory settlement for both the parties. Now we move on to the British period. We have looked on to the ancient times. Now when it comes to the British Raj rule in India, ADR mechanisms were initiated by the East India Company during the British Raj rule, and through Bengal Resolution Act 1772, then Bengal Regulations 1772, 1780, 1781, they were designed to encourage arbitration. And these parties they had to submit the dispute of the arbitrator. They had to draw up a mutual agreement. In all the other cases in ancient times, we did not draw up a mutual agreement. And once an agreement is brought up and then it was brought for arbitration, the verdict shall be binding on both the parties. Now we have the Indian Arbitration Act of 1899. This is in tune with the English Arbitration Act of 1889. This is the first substantive law on arbitration, and it confined its application to the presidency towns of Calcutta, Bombay and Madras. So it did have a very limited territorial jurisdiction, so you cannot say it is a very good act, but then it sowed the seeds for arbitration practices in India. And all these acts are defects and were subject to severe judicial criticism because it was not acquiring the goals that it was supposed to achieve. Next one is in international arena we had the Geneva Protocol and Arbitration Clauses of 1923 and the Geneva Convention on the Execution of Foreign Arbitral Awards of 1927. So these two international covenants they were brought in India through the implementation of the Arbitration Protocol and Convention Act of 1937 by importing all the material relevant sections and provisions in these protocols and conventions into India. And through that, after 3 years, the Arbitration Act of 1940, which is some sort of a full-fledged arbitration act, and it replaced the Indian Arbitration Act of 1899, which had so many flaws, and also Section 89 and clauses A to F of Section 104(1) of the second schedule of Code of Civil Procedure. So these, as of 1940, we have two provisions: Arbitration Act of 1940 and the Code of Civil Procedure 1908, Section 89 and Section 104, dealing with providing for the provisions for conducting arbitration in case of civil disputes, especially in Code of Civil Procedure, and for generally for other matters under Arbitration Act of 1940. This is in tune with our contractual obligation towards the international covenants as well. So this amended and consolidated the law relating to arbitration in British India and remained a comprehensive law on arbitration even till 1996. Even for Republican India, this Arbitration Act was there for nearly half of a century. This was in vogue. But the thing was, the Arbitration Act 1940 had lots of pitfalls and shortcomings. Thing was, even though it was brought into effect to meet our requirements, to meet our obligations towards the international or the domestic standards, it was not achieving the goal. Practically speaking, it was not achieving the goal. And in this particular case, Guru Nanak Foundation versus Ratan Singh, the judgment said that the arbitrational proceedings has made the lawyers laugh and the legal philosophers weep, because even though experience shows and law reports bear ample testimony that the proceedings under the Act have become highly technical, accompanied by unending prolixity at every stage, providing a legal trap to the unwary, which means even though the Arbitration Act was enacted to reduce the burden on courts, to reduce delays to make it less time consuming, but then it did not achieve all these goals when you coming to the practical result of those acts, because there was enormous delays and there used to be a lot of court interventions, and this frustrated the very purpose of arbitration as a means of expeditious resolution of courts. So in regular courts, there is some sort of delay in litigation, delay in proceedings, etc. Similar kind of delay was seen when coming to arbitration proceedings as well. So the delays which were found to have occurred before regular courts also found to have got reflected in the arbitration proceedings under Act of 1940. So the purpose for which the Act was brought into effect, so it did not achieve its purpose. It was totally a failure. So in Supreme Court in several cases repeatedly pointed the need to change the law because it was not happening, the purpose was not getting achieved, and the government of India though thought it necessary to provide a new forum and procedure for resolving international domestic disputes quickly. So likewise, after post-independence period, we have the Industrial Disputes Act of 1947, Section 12 deals with the duties of conciliation officers. So you can see a reference of ADR mechanisms in certain statutes even at the time of independence itself, in spite of us having the Indian Arbitration Act of 1940. Then we have the United Nations Commission on International Trade Law, UNICITRAL model. They gave a model on international commercial arbitration in 1985. So we have another international covenant as well, international commission as well. And in 1989, the Departmental Advisory Committee on Arbitration Law recommended that there should be enacted a new act to embody both the existing statutory law on arbitration and the relevant common law principle, the structure and language of unilateral model law. So the requirement was you have the new act. So they were about to enact a new act, and the new act should have the provisions of the international covenants, commissions, etc. All the international obligations had to be meted out through this new act. Then it should be in conformity with the common law principles, and it should also be in conformity with the existing statutory law dealing with the normal code legal proceedings. So all these things had to be taken into consideration, and the new act had to strongly follow the structure, language, and the spirit of unilateral model law. So it was a model law. And finally, we have, after the gap of 7 years, Arbitration and Conciliation Act of 1996. So it repealed almost all existing statutes governing the law of arbitration, but still, Industrial Dispute Act, that provision was still there. And it consolidated earlier enactments, codified principles established by recent case laws. Even the common law principles were included. They introduced changes designed to improve the fairness, speed, and cost effectiveness of arbitration, and incorporated certain provisions and even the spirit of unilateral model law. So finally, this act, the part 3, consists of commendable features of conciliation. Earlier the name was Arbitration Act. Now under the new act we have the term arbitration and conciliation. Both are coined into the title of the statute. And under part 3 there is a separate chapter for conciliation distinct from arbitration, with a view to bolster up the mechanism of ADR system in India, to show that there are various methods of ADR in India, not just arbitration. And it has got a statutory recognition, became an effective instrument for dispute resolution, and guarantees independence and impartiality of the arbitrators irrespective of their nationality. So this act is some sort of transcending nationals, because even foreign awards, foreign arbitration agreements, they also find place in this act. The new Act of 1996 brought in several changes to expedite the process of arbitration, and it is a non-adversarial mode. Now in 2002, Section 89 of the Code of Civil Procedure was also incorporated. By amending it, Section 89, a brand new act is brought into it. It still has some sort of defects in its legislation, etc., but still it is still there in a CPC. Next, we have the Industrial Disputes Act, Section 10A 11. 10A deals with the voluntary reference to arbitration. Section 11 deals about the powers and duties of conciliation officers, arbitration officers, etc. All these things are used to complement and supplement the earlier existing conciliation clauses, arbitration clauses under the Industrial Disputes Act. And another important point is, in disputes arising across national frontiers covering the field of private international law, ADR has a special significance to combat the problems of applicability of laws and enforcement. Thank you.